Here we go for part two of Local 6 Legal Line with attorney Mark Bryant of the Bryant Law Center in Paducah and Louisville. Topic is personal injury. Your questions answered at 1-888-208-6946. And we have someone who says, I run a lawn service and one of my guys broke his ankle when he stepped in a hidden hole in someone's yard. He's got medical bills. He can't work. Is there any way to recover this from the homeowner whose yard we were mowing at the time?
God, that sounds like a law school question. The answer is probably. The truth of the matter is that if you're invited onto somebody's property, they have an obligation under the law to their invitees, which you would be, to see to it that their yard is safe for you. And under that circumstance, the fact that it was a hidden hole and they did not tell you about it, you could certainly file a claim. Assuming that they have homeowners insurance, their homeowners insurance policy would cover your lost wages, they would cover your pain and suffering, and they would cover any medical expenses that you have. So yeah, that is a personal injury case, and you certainly ought to make that claim.
Next question comes from Raymond, who says, I suffered neck and back injuries when I was involved in a car accident with a teenage drunk driver. In addition to suing him and his parents, can I also go after the liquor store that sold him the alcohol, even though he used a fake ID?
Yeah, the answer to that is clear that you can. The fact that, in Kentucky we have what's called a Dram Shop Act, and that allows you to sue sue providers of alcohol if they knew or should have known that somebody was getting intoxicated on the premises, or if they were selling like to a minor and they should have known. And if, for example, the minor had a fake ID, the people that work in the stores are supposed to know. They've been trained to find that that person is underage, and so they are responsible for selling it. So yes, you can certainly make that claim and recover. There have been some good verdicts here in McCracken County over those very issues under the Dram Shop Act.
Have about 1 minute left in this final segment for today, and we have a question from someone. Probably see this quite a bit, and she says, my teenage daughter drives our golf cart all over the neighborhood. Usually her friends are in the cart with her. She's a safe driver, but if they have an accident, does our auto policy cover this? And it doesn't say whether or not she is of legal 16-year-old age.
It doesn't say it, but I'm here to tell you that most insurance policies do not cover golf carts. And so you need to look at your insurance policy. You need to call your insurance agent and put it in writing too, because I'm telling you, just because they might even be a friend of yours, your agent might be, but insurance companies don't have any friends. They take in premiums, and the way they make money is they don't pay them out. They don't pay out. So if they tell you that it's covered, be sure they put it in writing. And if they put it in writing, then you've got something to base it on should your daughter have an accident. But the best thing I would advise you to do is don't let her do it. Let her do it on a golf course or somewhere, but keep her off public streets. Because if for example, if she's not of age and doesn't have a driver's license, there is a very good chance that she could get a ticket for doing that. And you've got to have these golf carts have got to be approved in order to be out on the roads. There's a lot of legal issues involved in that question.
The Honorable Mark Bryant, Bryant Law Center, Paducah and Louisville, our guest on today's editions of Local 6 Legal.